What do employers need to know about California's sick leave law?
The Healthy Workplaces, Healthy Families Act of 2014, which is otherwise known as California's paid sick leave law, for the first time requires all California employers to provide their employees with at least some paid sick leave. Among other things, the law provides that employees begin accruing sick leave on the first day of employment, and also provides that employees accrue sick leave in the amount of at least 1 hour for every 30 hours worked, although an employer can cap the total amount of sick leave that an employee accrues at 48 hours or 6 days per year.
What are an employer's health insurance obligations while an employee is on FMLA or CFRA leave?
Both the FMLA and CFRA require an employer to maintain an employee's health insurance for the entire period of time that that employee is out on leave, in the same manner as if that employee had been actively working during that time.
Can an employer require a substitution of accrued paid time off during FMLA or CFRA leave?
Yes, an employer may require an employee to use some type of accrued paid leave, such as vacation leave or annual leave, while on FMLA or CFRA leave.
How do I calculate leave if my employee's schedule changes from week to week?
Right. For employees whose work schedule varies from week to week, an employer determines the amount of leave to which they're entitled to under the FMLA and CFRA by looking to the hours that employee has worked on average over the 12-month period prior to the start of the leave.
Can an employee continue on leave after exhausting FMLA or CFRA entitlements if he or she remains unable to work?
Possibly. If an employee's serious health condition for which he or she had been taking FMLA, CFRA leave qualifies as a disability under the Americans with Disabilities Act or the Fair Employment and Housing Act, the employer would be under an affirmative duty to engage in the interactive process with that employee to determine whether continued leave may be a reasonable accommodation that would allow the employee to return to work.
How should an employer calculate and track pregnancy disability leave once it becomes baby bonding leave?
So an employer has to be careful how to track the various leaves when an employee is taking leave because of a pregnancy-related disability and then continues on leave after the baby is born for baby bonding time, because that leave can be designated, that entire period of leave can be designated as FMLA leave. However, under California law, the California Family Rights Act, or CFRA, only applies to the baby bonding time. It does not apply to pregnancy-related leaves. Those are covered by a different law, the pregnancy disability leave law.
Calculating leave entitlements can be confusing. Doing it incorrectly can cost you. Get the tools you need to do the job right. Get your copy today.